Hi, my name is Abhishek. I'm a legal intern at LEXIS and Company. So today's my topic is personal choices, the constitution's endurance, a SALAMAT AMSARI case. So before proceeding with the topic, I request you to please like, share and subscribe the channel LEXCLIQ for more updates. So what is the issue? So the Allahabad High Court cancelled a case against a Muslim man filed by a parents of his wife who converted to Islam before marrying him. So the verdict comes as a reminder of the constitution's cherished values in the backdrop of some state governments bringing in legislation against what they call as love jihad. So what is this case about? So in this case, the petitioner Salamat Ansari had Priyanka Kharwar had approached the High Court and seeking order to quash the FIR that was lodged against them. The FIR alleged that a series of crimes had been committed. These include one under the section 366 of the IPC, which criminalizes the abduction of a woman with the intent to compel her to marry against her will. The petitioners claim that they were both adults competent to contract a marriage. They had in fact wedded long before in August 2019 as per Muslim rites and ceremonies, and only after Ms. Kharwar had converted to Islam. So what were the state's argument in this? The state resisted the claim of the couples that they married by will. It argued that Mr. Ansari and Ms. Kharwar's partnership had no sanctity in the law, and it held that a conversion with the singular aim of getting married was illegitimate. In making this argument, the government relied on a pair of judgments delivered by single judges of the Allahabad High Court. On the judgment in Noor Jahan versus State of UP 2014, the High Court held that a conversion by an individual to Islam was valid only when it was dictated on a change of heart and on an honest conviction in the tenets of the newly adopted religion. Additionally, it ruled that the burden to prove the validity of a conversion was on the party professing the act. So therefore, in the present case, it was argued that it was for the woman to establish that her conversion was born out of her conscience. So what is the High Court ruling now? The division bench rejected the above theory. It held that a judgment in Noor Jahan was incorrectly delivered. The court said that it did not see Priyanka Kharwar and Salamat as Hindu and Muslim. It rather saw them as two grown-up individuals who, out of their own free will and choice, are living together peacefully and happily. So, what are the High Court's observations? The High Court declared that the religious conversion, even when solely for the purpose of marriage, constitute a valid exercise of personal liberties. It ruled that the freedom to live with a person of one's choice is intrinsic to the fundamental right to life and personal liberty. So the order thus recognized that the Indian society rested on the foundation of individual dignity. So this means that a person's freedom is not conditional on the caste, creed or religion that her parent might claim to profess. By invoking the Supreme Court's judgment in Puttaswamy case, the High Court held that an individual's ability to control vital aspects of her life in hers is her right to privacy. This promise includes the preservation of decisional autonomy on matters including of personal intimacies, the sanctity of family life, marriage and procreation, the home and the sexual orientation. So according to the High Court, the Constitution is violated every time matter of intimate and personal choices are made and vulnerable to the paternal whims of the state. So what is the underlying idea? So the Article 25 of the Constitution expressly protects the choice an individuals make. In addition to the right freely to profess, practice and propagate religion, it guarantees to every person the freedom of conscience. The conscience is certainly not something that the state can examine as a function of its sovereignty area. The right to freedom is promised because questions of conscience are matter of ethical autonomy. So the provision's ultimate purpose is to allow individuals the freedom to lead their lives as they please. So what is the UP government's response though? Already seemingly in response to the judgment, the UP government has introduced an ordinance. It makes not only religious conversions that are forcefully obtained an offence, but that also declares void any conversion found to be made solely for marriage. In supporting the law, the state will likely rely on the 1977 Supreme Court judgment in Rev. Stanilios versus State of Madhya Pradesh. There the court upheld on grounds of public order to the earliest anti-conversion status in India. So the Madhya Pradesh Dharma Swatantra Adhiniyam 1968, the Orissa Freedom of Religion Act 1967. These laws required that a district magistrate be informed each time a conversion was made, and they also prohibit any conversion that was obtained through fraud or illegal inducement. So that's it. Thank you.